G'day, my name's James Ballantyne and I'm the principal of Ballantyne Law. We're a commercial property and estate planning firm based in Brisbane and the Gold Coast. I'm here to talk to you about some of the common questions we get asked by our clients in relation to estate planning. So what is estate planning? Generally it deals with two scenarios. The first, the inevitable, when you pass away, what happens with your estate, to your loved ones, to your assets, to your children and so on. The second, what happens if you lose the ability to make decisions for yourself, what we call loss of capacity. So is an estate plan just a will? The answer is no. There are a number of documents and considerations that people have to give when they're making their estate plan. Of course, a will should be the centerpiece of any estate plan. The will can be complex, it can be simple, it can be conventional, it can include multiple trusts, it can include life interests, or it can be one page. The second primary document that should be considered with an estate plan is an enduring power of attorney. This document allows someone to appoint a person or a group of people to make decisions on their behalf about personal, including health matters, or financial matters, or a combination of them both, in the event the person is unable to make those decisions themselves if they lose capacity. The Advanced Health Directive is another important document that we're finding people are more and more doing. What an Advanced Health Directive does is allow you to give specific written direction about various healthcare options that are available to you in the event that you lose the ability to make decisions for yourself. So it works with the enduring power of attorney, but while under the enduring power of attorney, your attorneys make decisions on your behalf, under an Advanced Health Directive, you make the specific decisions. Guardianship issues are another important aspect of an estate plan. While we can appoint people to look after our children when we or our partner passes away, what a lot of people like to do is give specific guidelines and guidance to those guardians about their wishes in relation to their children's upbringing. Things like education, religion, cultural activities, visiting family members and otherwise can all be included as part of an estate plan. Superannuation is a really important one. A lot of people's assets now are tied up in superannuation and they don't necessarily realise that those assets within super don't form part of an estate automatically when you die. Those assets are legally owned by the trustees of the superannuation fund, and there's a variety of mechanisms under which the benefit of those assets can pass. Things like nominations, binding nominations, non-lapsing binding nominations, lapsing binding nominations, reversionary pensions, other allocated pensions are all part of a superannuation plan and part of an estate plan. A lot of people now own assets through discretionary or family trusts or even unit trusts and other forms of trust. Those assets also don't form part of an estate automatically, but control of those assets need to be considered as part of an estate plan. If you have an interest in a business, that needs to be considered as part of your estate plan, particularly if there are other owners in the business with you. While the death of an owner can be catastrophic for a business, a well-considered estate plan can allow that business to continue while giving value to the beneficiaries of the deceased person. Things like buy-sell agreements, insurance-funded agreements, put and call options and other documents are available under an estate plan. We're finding that there's increasing numbers of blended families out there where people are on second relationships and have children from earlier relationships. And sometimes it can be a balancing act between ensuring the interests of your children from an earlier relationship and your new partner's interests are protected. And a good estate plan needs to consider those things. Insurance, whether it's life insurance, trauma, risk, TPD, income protection, are all aspects of an estate plan, considering whether there's sufficient insurance resources needed to meet liabilities and support the family, and also considering who owns those insurance policies, whether they're owned by an individual or by a superannuation fund or a business partner or someone else, are all important parts of an estate plan. We're seeing an increasing focus on digital asset, whether that's cryptocurrency, online accounts, online passwords, online photographs. All of these digital assets need to be considered under an estate plan. So what actually happens if you die without a will? Well, under the Succession Act, which is the law in Queensland that deals with wills and estate administration, you're called intestate. Now, under the rules of intestacy, a one-size-fits-all approach applies, which means that certain people, by virtue of their relationship with you, will automatically receive an entitlement to your estate. Now, that can end up not being an issue if you have relatively straightforward situation, but in many situations, the wrong outcome can occur. So if, for example, someone has separated from their partner and dies without a will, their partner may be entitled to receive part or all of the estate, against the intentions of the person who passed away. This can obviously cause unintended consequences. It can cause a high level of stress for the people who survive you, and can cause increased cost to your estate and to your beneficiaries. So there's quite a few considerations that you need to think about if you're considering doing an estate plan. One of the first is to think about what you actually own, what assets form part of your estate, what assets might not be owned by you but might be controlled by you, and I touched on them earlier, things like trust assets, things like company assets, things like superannuation. If you own assets with another person, how are those assets held? Whether they're jointly held or held as tenancy in common will be an important part of your estate plan. And as I mentioned earlier, superannuation is a big one. How are superannuation death benefits dealt with? There may be taxation considerations and nomination considerations that need to be had. While a lot of us know who we want to receive the benefit of our estate, and that's generally our family or close friends, decision making is an important one. Who are the people who you trust to implement your wishes and decisions? That could be a family member, that could be a trusted advisor, it could be a friend, it could be someone independent. If your beneficiaries have some kind of special disability or special needs, whether they're children under the age of 18, whether they're suffering from a disability, or even if you consider that they're not able to manage what might be a substantial resource, you can put in place assistance for those beneficiaries through the use of things like testamentary discretionary trusts. And finally, blended families is another big one. You need to balance the interests of your children from an earlier relationship with the interests of your new partners. You also need to think about what the consequences of that estate plan, what are going to be. What are the revenue implications? What are the taxation implications? What are the stamp duty implications, if any? And finally, if you are thinking about making a decision to leave someone out of your estate, what are the consequences for the estate for that? Is your estate going to be exposed to litigation, family provision, or other attacks? So can you do an estate plan yourself? Well, of course you can. You can do many things yourself. There's no legal obligation to use a lawyer when you're doing your estate plan. Unfortunately, not all wills are the same. We see a lot of matters where people have prepared their own handwritten wills, or they've used ready-made precedent wills from the post office or from a news agency, or even gone online and used an online will kit. And in a lot of cases, those documents are either not prepared correctly or not executed correctly, or don't properly deal with considerations such as I've touched on today. There is a real cost of getting it wrong, both from a financial perspective in terms of the amount that your estate might need to pay to rectify any issues, and from a stress and time perspective of your beneficiaries during what could potentially be a difficult time. So if you're considering doing an estate plan, what do you need to do next? Well, my view is that you should speak to a solicitor, and preferably a solicitor who has a practice in estate planning. As I've touched on this afternoon, there are a lot of considerations in this area, and all estate plans are not the same. We at Ballantyne Law practice in estate planning, and we have a very helpful online induction process that allows you to go through some of the issues I've touched on this afternoon before you come in and see us and have a lawyer meet with you to prepare your documentation. I'd be happy to have a chat to you if you've got any questions about the matters I've raised this afternoon, and I look forward to hearing from you. Thanks very much.